Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
You're on mute.
Thank you very much, Mrs. Williamson. Well, I was unmuted and they came on over. We're still trying to learn this Zoom oral argument business. And hopefully, by the time we finally learn it, we'll transition back to having live oral arguments. I know that everybody's excited for that. No less of which are our three judges. My name is John Bailey. I'm from Eastland County. I'm the Chief Justice. I'm happily joined by two relatively new justices, Justice Stacy Trotter from Odessa, and also Justice Bruce Williams, who came from Midland. He's now a resident of Eastland County as well. But with that being, pardon?
Good morning.
Good morning. So with that being said, we'll call our first case. We'll call cause number 11-18-267 CR Bobby Ray Ruiz versus the state of Texas. Ms. Clayton, are you ready to proceed?
I am, Your Honor.
You may.
Mr. Chief Justice, and may it please the court, my name is Allison Clayton. In addition to having my own practice, I am the Deputy Director of the Innocence Project of Texas and the Adjunct Professor of the Innocence Clinic at Texas Tech School of Law. I represent the appellant, Bobby Ruiz. This is a case that is built like a house on rotten wood. In the 2-week trial below, there was a lot of evidence presented. There was evidence presented about the victims in this case. There was evidence presented about the appellant, Bobby Ruiz. There was evidence about his co-defendants, and there was evidence about the crime scene. There was evidence about what happened after the murders occurred in this case. But when it comes down to the brass tacks, the evidence putting the appellant at the scene of the crime is twofold. First is a false confession from one of Mr. Ruiz's co-defendants. And second is the incentivized testimony of a jailhouse informant. That's it. And as you'll hear today, and as you'll see when you go through the record, those two pieces of evidence are rotten to the core.
Now, Ms. Clayton, you did not prepare the brief that was filed on behalf of appellant?
I did not.
And it was authored by, who is now Judge David Rogers of the 142nd in Midland County. Do you stand on the same issues that are raised in the brief as filed by Judge Rogers?
I do. I kind of think I have to. I don't think I get to pick on that. So yes, I do. I think we're kind of bound to those. Unless if you see something else you want me to raise, let me know and I'd be happy to. But no, I
think it's more of a question. Are there any issues that you feel should be abandoned?
No.
Okay.
No, and just the cumulative effect, when you look at all 13 points of that, I mean, that should hit you first and foremost, right? Whenever you're looking at most appellate briefs, there's like 2 or 3 issues. This is 13 legitimate issues that Mr. Rogers raised. Because
what we'd like you to address at the outset are issues 2 and 3, which go hand in hand, that concerns the corroboration complaint that's been raised on appeal. Would you address that for us, please?
I would be happy to. Thank you so much for telling me what it is you guys are interested in. That's always something we're kind of wondering as litigants. So as we all know, or at least we should know, when you're evaluating evidence, you have to look at the source, right? And the thing that we're dealing with in issues 2 and 3 are things that are relative to the source of the evidence. Some sources are better than other sources. They're more trustworthy than other sources. The Texas legislature, recognizing that some sources are just simply not as trustworthy, has created essentially a subclass of evidence based on the source of it. Evidence from these sources by mandate has to be treated with suspicion. The legislature first did this over 50 years ago.
As we understand your complaint as it pertains to, and specifically issue number 2,
yes,
is that there was testimony provided by Castillo, accomplice witness testimony, and also testimony provided by Mata, which has been characterized by you on appeal as jailhouse informant testimony. And it's your position on appeal that one cannot corroborate the other, correct?
Yes.
So is it still your position that the testimony presented by Mata would be characterized as jailhouse informant testimony under 38.075?
Oh, absolutely it is. 100% it is, because Mata took the stand at the Ruiz trial, and her testimony is that everything the jailhouse informant said is not true, that she was not there, that as far as she knows, that the appellant was not there. So that's her testimony. But the actual informant testimony, that's the testimony that puts Mr. Ruiz at the crime scene. So
if it is to be jailhouse informant testimony under the statute, isn't it necessary that the testimony from the informant consist of statements made to that person by the defendant while the informant and the defendant were confined together at the same time in the same facility?
Well, that is how you define jailhouse informant testimony.
So what evidence in the record consists of any statement made by the defendant, Ruiz, to Mrs. Brown, who is the alleged jailhouse informant?
There's not. He didn't make any statements from, I should say the jailhouse informant didn't say, this is what Mr. Ruiz told me. But those statements were still used to obtain his conviction.
But where's the statements made by the defendant to the jailhouse informant? Isn't that a requirement for that statute to be applicable?
I don't think that it is, no. Because if you look at it, you're looking at evidence that's offered by the jailhouse informant, and the evidence offered is, the hearsay statements from Mata. So
let's assume, for sake of argument, that the testimony would fit within the requirements of 38.075. Is it your position that jailhouse informant testimony cannot be corroborated by accomplice witness testimony and vice versa?
Yes.
And what case law do you have to support that position?
There's not case law that's directly on point on this, because that statute 38.075 is a pretty new statute. And actually this is something that you guys need to know, because it's really not in the briefing, although I suspect you've probably already found it anyway. And that is, the court, this is not the first time that this court has dealt with this body of evidence. In 2016 and 2017, the first of these cases, which was the Desiree Mata case, came through the court. I was the attorney on that case. And in that case, we had the 38.075 issue, because the trial court failed to instruct the jury that the jailhouse informant's testimony had to be corroborated by independent evidence. That case was made very difficult, however, by the fact that the trial attorney hadn't preserved the error. Your Honor, I see that you're talking, but you're on mute, and I want to make sure I'm not talking over you. Okay, cool. So we had that issue. It was a really high standard. We had to have the Almanza egregious harm standard that we were trying to overcome, and frankly, we just couldn't overcome it. But in the harm analysis of that case, this court did something that was kind of out of left field. No one really saw it coming, and I think it was because the statute was so new at the time. But what the court did—
In the Mata case that you've mentioned, which has already been processed through direct appeal, was essentially the same testimony presented at her trial as in Ruiz?
Yes.
Okay.
Yes, it's really
and was the same issue raised on appeal in Mata, that jailhouse informant testimony? Was it essentially the same testimony from statements made to Brown while she was confined in an Alabama County jail with Mata?
It was, yes.
The same issue was raised on appeal in that case?
It was.
Okay.
The difference is, in that case, is that the issue wasn't preserved at trial. So we didn't get the jury instruction, but the trial attorney didn't object. So we had this crazy high egregious harm standard that we just couldn't clear. And so what the court did whenever it was doing its harm analysis is it used the accomplice testimony to corroborate the informant's testimony. And like I said, no one really saw that coming. And frankly, we didn't like that very much. So we applied for a petition for discretionary review. And whenever we still couldn't clear the Almanza standard, but whenever the Court of Criminal Appeals denied PDR, the interesting thing about that case is the concurrence that issued upon denial. And this is something that's not in the briefing, but you need to know. So let me go ahead and give you the citation for that. That's in the Desiree Mata case. And the citation is 542 Southwest 3rd, 582. And in this concurrence, it's authored by Judge Hervey, but it's joined by Judges Richardson, Newell, and Walker. What they said is they said, at the end of the day, she still can't clear Almanza, but this idea of using an accomplice testimony to corroborate the informant testimony, they showed some trepidation on it, right? They never really flat out came out and said, this is something that we shouldn't be doing, because they didn't need to do that because of Almanza. But at the end of the day, they said, they kind of looked at the legislative history of the statute. They looked at a couple of things, and they said, we don't know that this is the thing to do. And really that PDR denial, I think, was directed more at the legislature. But at the end of the day, you still have the Court of Criminal Appeals looking at this very body of evidence, showing some trepidation about this particular approach. And we know it's been on the books since like the late 1960s, early 1970s, that you cannot use one accomplice's testimony to corroborate another accomplice's testimony. And again, this is all going back to the source. These are a subclass of evidentiary sources that the legislature has said, we will treat these with automatic suspicion. So that's the reason why we don't use these sources to corroborate each other, because what happens is you end up with convictions like this that are based upon uncertain evidence that should be viewed and is highly suspicious, that's not being properly reviewed the way the legislature has mandated, the way that it wants to mandate it. So, the jury in this case was instructed that the accomplice witness testimony had to be corroborated. It was instructed that the informant testimony had to be corroborated, but it was not instructed that the two could not corroborate each other. That was requested. I can tell you by very intentional design, that issue has been preserved. This issue has come before the court before in the Johnson case. That was a 2017 case, which I believe is cited in the briefing. But in that case, what this court did is it punted. It said, we will assume without deciding that the jury instruction should have been given. The instruction that one cannot corroborate the other should have been given. So there's a little bit of case law that this court has done previously on it. And in that case, the court mentioned how there is a split in the circuits between this. That the Waco circuit says it's not required, but in a published opinion, the Corpus Christi circuit said that it was required, and that the Houston Court of Appeals, the first district, has relied upon the Corpus Christi case, saying that yes, that instruction is required. We shouldn't be using one to corroborate the other, and the jury needs to be instructed as such.
Ms. Clayton?
Yes.
What about that cigarette lighter? Does that corroborate?
No. Or if it corroborates, it doesn't corroborate what it's supposed to corroborate, right? The evidence has to corroborate that the defendant was there at the time of the offense. It has to link the defendant to the offense. A cigarette lighter on a windowsill of a house that you've been to before doesn't mean you murdered somebody, doesn't mean you were there at the time of the murders. It just means you were there at some point in time. And if you look,
couldn't he have been convicted? Because we don't know, but he was charged as a party as well as a principal. So couldn't that be supportive of evidence as a party conviction?
If you're looking at it through the legal sufficiency viewpoint, maybe that would be part of the calculation in that case. But what you're looking at whenever you're dealing with 38.075 and 38.14 is corroboration of the defendant being there at the time of the offense, like corroborative evidence linking the defendant to the offense. So yes, that lighter can come into certain calculations, but not into this one. Now, the standard of review is a really important thing, and I know that it's not lost on this court. The court talked about this court talked about it in its case, the Johnson case, that said that the standard of review is some harm. And again, like, you really don't have to look that far to see that Mr. Ruiz suffered some harm. If you look at the false confession, right? This is, I call it a false confession because it is a false confession, but it's the statement of the accomplice witness, the co-defendant. He said that Mr. Ruiz drove to the house the night of the murders, but there's no evidence indicating that he was ever in a car with the other co-defendants that night, that he was ever in any situation with the co-defendants, around the time of the murder. There's nothing that supports that statement. So, to answer your question a little bit further, Judge Trotter, whenever we're looking at these things, that's what we're looking for. The statement that hurts Mr. Ruiz from the accomplice witness is the testimony that Mr. Ruiz drove out to the victim's house in the car with these other people. Does a cigarette lighter on the windowsill say anything one way or the other about that? No, that's the evidence that has to be corroborated. That's what they have to support. And if you really read the record, and I know you guys will, really read the briefing, whenever Mr. Malling, whenever his box pops up on the screen here in a moment and you listen to him talk, really listen to what he's talking about, the evidence, because the evidence, there is a lot of evidence, but the evidence that puts Mr. Ruiz at the scene of the crime are these two pieces of evidence, the false confession from the accomplice witness and the incentivized testimony from the jailhouse informant. That's the only thing that they have, and the only thing that could possibly corroborate it is each other. And that's not the way the Texas law is designed. It's not the way that that we should be obtaining lifelong convictions against people. So, there is a lot of evidence in the case, but the jury should have been properly instructed on how to interpret and how to handle this evidence. That was the trial court's job. It did not do that job. And accordingly, it obtained this conviction in violation of Mr. Ruiz's rights, and we ask that the court reverse the conviction.
Thank you very much, Mrs. Clayton.
Thank you, Your Honor.
Mr. Mallon,
You're
you're on mute. Before the timer starts, Mr. Mallon, I see that Tarrant County banner behind you.
Yes, Your Honor.
So are you with the Tarrant County DA's office?
I retired from the Tarrant County
Okay.
Attorney's Office
All right.
in 2017.
All right. Just wondering. We can you can put a background up and show you're on the surface of Mars for these Zoom arguments.
Yeah.
I was just checking to see.
I'm kind of used to that banner.
Sure. No, that's fine. Might be good luck. All right. With that, would you like to proceed with your argument?
Yes, may it please the court.
Yes, sir.
Chuck Mallon for the state on behalf of Philip Verlo, the district attorney for the 106th Judicial District. The court was, and Ms. Clayton were talking about cooperation of jailhouse informant under 38075. I think there was plenty of evidence to corroborate the statements that were made by her testimony and the statements made to Detective Porter by Angie Brown.
Mr. Mallon, I'm going to ask you the same questions that I presented to Ms. Clayton, and that is, do you believe that 38075 actually applies to this circumstance?
Yes, I do, Your Honor.
And what statements were made by the defendant, Ruiz, to Mrs. Brown when they were confined in any facility at the same time? Isn't that what the statute requires?
I don't think there were. I was addressing the corroboration of the jailhouse under 38075. We're talking about Angie Brown.
Correct.
That's correct.
Doesn't the statute require that the defendant, him or herself, make statements directly to this jailhouse informant while the two of them are confined together at the same time?
Well, okay, that's a good question. And here's the deal on that. The statements made to Angie Brown were made by Desiree Mata. Desiree Mata was a party to the offense. Desiree Mata was a co-conspirator with Bobby Ruiz, the defendant, and she was a party under 702, and those statements should come in against Mr. Ruiz as a
Mr. Mallon, though, in that light, Mata is an accomplice, correct?
Mata, she's an accomplice and she's a party under 702. She aided and abetted. She aided and abetted and assisted in the murder.
No, hang with me. So the comments that Mata makes to Brown, and we know that they occurred in a jail, so we have jailhouse that seemingly attaches. But if
Yeah.
Brown comes and testifies about what Mata told her about it, could that possibly be another instance of accomplice testimony? In the sense of it's statements relayed by an accomplice
Yes.
and
it
not the
could-
defendant.
Yes, it could be. And then you look at 3814. That's correct. I
All
mean,
right,
here's
let's
the
carry
thing.
that to its logical extreme. Can
But-
one accomplice's testimony corroborate another accomplice witness's testimony?
Well, the Court of Criminal Appeals has said no, but it wasn't, her testimony was not you don't have to look to her testimony was corroborated by Angie Brown. Here's the deal. You got two statutes, 38075 and 3814. There is nothing in 38075 which prohibits the corroboration be by an accomplice. The accomplice can corroborate a jailhouse informant, and a jailhouse informant can corroborate an accomplice. There's nothing that prohibits that. Nothing.
Well, let's assume for purposes of argument that the jailhouse informant statute would apply,
Yes, sir.
and it would be appropriate for an accomplice to corroborate the testimony of a jailhouse informant and vice versa.
Yes, sir.
But let's assume further that we have two accomplice witnesses knowing that neither can corroborate the other's testimony. So we must disregard that testimony and look to the record and determine whether or not is there any evidence that tends to connect the defendant to the offense. So assume with me that Mrs. Mata and Mr. Castillo are both characterized as accomplice witnesses. Can you outline for the court what other independent evidence there is in the record that would tend to connect Mr. Ruiz to the offense, either as a principal or a party?
Well, question. Okay, because assuming as an accomplice, there's nothing, but you can go to 3875. There's plenty that corroborates the Angie Brown statement, tending to connect Ruiz to the offense.
And what evidence is that?
Okay. She describes four perpetrators. The four perpetrators were Dan Sosa, Desiree Mata, Juan Castillo, and appellant Bobby Ruiz. That's true. That's all been proved beyond a reasonable doubt. Defense occurred on the borderline of Texas and New Mexico. That's true. And it was proven. Juan Castillo took the victim, John Allen's surveillance equipment, and that's true. It was proven beyond a reasonable doubt. He did take that surveillance equipment. John Allen's body was found where it was Angie Brown described it would be found. Desiree had an appointment with Child Services, Protective Services. That's true. She was going to use that as her alibi. Desiree had a baby at home. That's true. Sosa had been convicted of a previous murder, and he was convicted of a previous murder. If you look at the notes, it states exhibits 69 and 70. They corroborated. Appellant was shot 2 weeks prior to this incident. The hospital records were introduced, which corroborates that. That corroborates Angie Brown's statement that Ruiz was shot. The weather was rainy on that day. That was corroborated. And the DNA. The DNA was found on the lighter, and although it was inconclusive as to Bobby Ruiz, he wasn't excluded. So her testimony was abundantly corroborated. Is there any other questions on that issue? I'd like to go on. They raised in their brief that the trial court erred in submitting the law of parties. Well, you know, obviously he was a party to this offense. The evidence clearly demonstrated that appellant was guilty as a party. David De La Paz testified to Juan Castillo's story, and appellant and Mr. Sosa and Desiree Mata all drove out to the Allen house. Desiree Mata got out of the car. She knocked on the door. They opened the door and all the perpetrators rushed into the house. That's when the appellant Ruiz shot Doyle at the front door and John Allen in the back bedroom. Castillo confessed about the crime and the participants to David De La Paz, and De La Paz testified at the trial. Appellant helped stage the crime scene by planting the glass meth pipe in John Allen's hand to make it look as if it was a drug deal go bad. Juan Castillo admitted all the details of defense detective Porter. Appellant's DNA was not exclusive as a contributor, discovered on the red lighter. And according to Angie Brown, appellant shot both John Allen and Jay Doyle. So I believe it was sufficiently corroborated. The next issue that the defendant raises, I'd like to address was the expert on false confessions was excluded, okay, as being not qualified. If you look at the testimony of, it was a Dr. Charles Keenan. If you look at the testimony of Keenan, he admitted on cross-examination by Mr. Furlow that there were no periodicals dedicated to the field of false confession analysis. He further confirmed there are no publications or he did no publication on false confession. He had there was no mental status review of Juan Castillo, who was the individual that they were looking at to see if this confession that he made to Porter was false. He did not, Dr. Keenan did not perform a mental status exam on Mr. Castillo. There is no potential error rate as far as any type of field of false confession. In fact, there's no such scientific field of false confession. In science, there are two types of fields. There's hard science and there's soft science. Obviously, psychology is a soft science, and that fits within false confessions. And there's no such field. And Dr. Keenan couldn't, they brought up the fact that, Dr. Keenan brought up the fact that when he viewed the video of Mr. Castillo, he said that Detective Porter made missteps in his technique, in that he alleged that there was manipulation by Detective Porter. He alleged that there was intimidation of Castillo by Detective Porter, and he alleged that he attempted to control during the interview Castillo. Well, they're just bare-faced allegations. Dr. Keenan never explains any of those and applies it to his allegation. So I think the trial court was absolutely correct in excluding this testimony. First, Dr. Keenan was not qualified. And second, that his analysis didn't come within the purview of scientific evidence, that it was a theory that is accepted by a dedicated field, that the theory was applied in this instance, and it was applied, the final prong was applied appropriately. None of those factors were met. And as far as the last thing I wanted to talk about was the admissibility of the Jerry Castillo interview with Eldon Whitworth, who is a private detective. State's exhibit, I mean, it was defense exhibit number 65, and it was excluded, and it should have been excluded, because if you look at state 65, it's a 48-page document. And within the document, when they pro-offered defense exhibit 65, they didn't attempt to fetter out any of the inadmissible as opposed to admissible portions of that document, that statement. So the trial court properly excluded defense exhibit 65. Is there any further questions by the court on any issue?
No, sir, I don't believe so. Thank you very much for your argument.
Thank you.
Ms. Clayton, you'll have 5 minutes for rebuttal. You're on mute. Or at least I can't hear you.
I can't hear you either.
Now I can. Now, please give it a try.
Can you hear me now?
Yes, barely.
Okay, I showed that I was off of mute, so thanks for letting me know.
Sure.
Okay, couple of things that I'm going to have to, I'm afraid, go kind of quickly. I really do need to address the issue with Dr. Keenan. If you look at the case law that the state relies upon, whenever it's saying that, you know, the field of false confessions is not a real field, that case law is 20 years old, and a lot has happened in the last 20 years. And in fact, in 2012, the Court of Criminal Appeals talked at some length about the field of forensic psychology. And this is not something that's included in the briefing. So you need the cite for this too. It's the case of ex parte so far. And the cite
And
on it,
is that considered to be a soft science?
I think it probably would be a soft science. The site, by the way, on so far is 2012 Westlaw 4713562. And in that case, that's a pretty straightforward denial of a petition for writ of habeas corpus. But in that case, Judge Cochran talks at length about the developments in the field of false confessions and all of the famous exonerations that we've had off of false confessions. And let's not forget the fact that if you look at pages 24 and 25 on the 8th volume of the reporter's record, that every single district court in the state of Texas, until this court, who has ever looked at Dr. Keenan, has certified him as an expert in this field. Like, it was a big deal whenever Dr. Keenan didn't pass the 702 hearing, because, you know, he's been around forever and everyone has been certifying. I say everyone, district courts across the state of Texas have been certifying him time and time again in this field. So,
and what were his credentials presented during the Dalbert hearing as to his prior testimony and his prior qualifications to testify on these issues in other courts?
Yes, Your Honor. If you go to his testimony starts at page 21 of the 8th volume of the reporter's record, but that is all in pages 24 and 25. So that is a valid scientific field. And let me tell you, if y'all want additional briefing on this issue or any other issue, I would be thrilled to be able to submit a brief to this court. I have the best nerds that tech law can offer that are also just waiting to have any kind of issue that you need briefed on this. So we would be happy to tell you about how, you know, 25% of wrongful murder convictions involve a false confession, how this is a very real field, and how it was erroneous for the trial court to deny Dr. Keenan the certification, the expert certification. And the reason why that's so important is because we're talking about the constitutional right to make a defense, right? Like, this is a constitutional issue, and that was a really important thing that Mr. Ruiz needed to be able to talk about. I mean, this is the enforcement of constitutional rights that we're dealing with here. And that ruling infringed upon his constitutional right to present a defense.
And Dr. Keenan's testimony was essentially directed at what would be classified as a false confession?
Yes. Oh, yes. The accomplice testimony is a false confession.
Okay. And isn't that why we have juries, for them to determine who's being truthful and who's not?
Well, that is why we have juries. He wasn't going to tell a jury, you know, this person's being truthful, this person's not being truthful. It's kind of like, you know, in a kidnapping case, whenever someone says, well, as soon as I had the opportunity, I would have run away. Well, that's why you need to bring in an expert to explain Stockholm syndrome. It's kind of in that same vein. This is something that most people are not going to think is a common thing. They're not going to be able to see how easily manipulated people can be. And so Dr. Keenan's purpose, as you'll see in the bill that they made off of his testimony, was really to tell the jury, these are the things that you need to be looking for. And these are my concerns. You can make up your own mind. You know, you look at the evidence, you compare the things, but at the end of the day, false confessions are real. And this is
And,
what.
and how would that testimony assist the jury in making a credibility determination?
Well, I mean, it would be able it would educate them to know that whenever they're seeing this man who looks pretty lucid saying these crazy things that are contradicted by the evidence, that, you know, that is possible for them to look at that and still say, oh, this guy is being corroborated into a false confession. It would just arm them further with an understanding of how the human mind works. Now that I really also need to talk to you about the issue on the corroboration. And Justice Bailey, man, you make such a good point. And that is that we're in a very weird situation here, right? Because 38.075 talks about statements the defendant made to the jailhouse informant. Ruiz didn't make any statements to the jailhouse informant. Ruiz's co-defendant made statements to the jailhouse informant that then were used against him. So that's kind of, I see what you're saying, Justice Trotter, like that really is an issue. But then the question becomes, well, then does it pop over to 38.14? Because then it would become accomplice testimony. And at that point, and we know that accomplice testimony cannot corroborate each other. So at that point, I think what we have to look at is how we're going to define testimony and which one of those statutes apply, because it's got to be one or the other. And for those reasons, if there aren't any other questions from the court, again, we're happy to provide post-hearing briefing if the court so orders it. Otherwise, we stand upon our request for the court to reverse the conviction against Mr. Ruiz. Thank you.
Thank you very much. Your case has been submitted. Ms. Williamson will adjourn us from this session. Afterwards, the court will resume with an 11 o'clock case. Thank you.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now adjourned.